All right, everybody, thank you so much for joining us for another session of Thought and Action. We're super thrilled to have you, and we're super thrilled to have Jason Rosenblum, and he is a lawyer that focuses on intellectual property law. That's patents, copyrights, and trademarks. And he's going to take us through the differences, and I think some really special nuances, and hopefully help you spend your money well and protect what you're creating. And the reason I wanted to have him on is because I know in this 2020 COVID land, that the entrepreneurial juices for a lot of people that I'm talking to are flowing, and people want to know, okay, now that I've created this thing, no matter how small or big it is, how do I protect it? And so I wanted to have Jason come on and give us some tips and tricks, and we'll get into your book a little bit too, because I think that if people want to continue this conversation, it'll be a good kind of segue into learning a little bit more. So just start me off. What are the different forms of kind of intellectual property? When you talk about protecting something, what are we talking about?
All right. Well, first of all, thanks for having me on. Always a pleasure to speak about this and help entrepreneurs and businesses that are starting up really understand what some of the basics are. Which, one of those is what is the difference between the different forms of intellectual property. So we have patents, copyrights, trademarks, and trade secrets also fall under that as well. So patents are about an invention, something new that you created. Whereas a trademark covers your brand. It covers the source of your goods or your services that you're providing, and it could be your brand name, it could be your logo, it could be a slogan as well. And then copyright covers essentially the expression of an idea. So a lot of people think that they can file a patent based off of an idea, but you cannot protect an idea by itself. But a copyright, if you write a book that covers your idea, your story, draw a picture of it, that's what copyright protects. So that's the expression of an idea. Copyright covers a lot of different forms of an expression of idea, everything from literature, photographs, graphic design, music, audio and video recording. So they all protect that. And then the last thing that I mentioned, which is trade secret. And most people know of trade secret from the formula for Coke. And the key is it's something that's a secret. It's a benefit that your business has that you keep a secret, whether it's a customer list, whether it's a procedure. But the key is keeping it secret. And most of that is done through contracts. One of the things to know is very early on, you need to decide, especially if what you have is maybe a procedure, is are you going to keep it a trade secret? Because all the other forms of intellectual property, you pretty much need to disclose it in order to protect it. So you don't file anything for a trade secret, you just keep it a secret and protect it, whether it's physical means, by lock and key, or if it's by contracts.
Right. Okay. So take me through, like, when is the ideal time to start the process of getting, a copyright or trademark? Like, when can you wait? Are you putting yourself at risk if you wait? What are the benefits to doing it early versus later, and when should you do it?
So I think you always should start thinking about it at the beginning. And I think it's wise to either do some research or at least speak to an attorney that practices in the area of intellectual property to kind of understand what you should start thinking about, and start maybe allocating assets to protecting it, or realizing this is something maybe we can't protect, so don't even bother with it and let's put the funds towards something else. In terms of trademark, though, one of the big things is if you're coming up with naming your business, or coming up with a new product, or, a platform as a service, you need to make sure that, one of the biggest things is if you pick a name, that you're not infringing on someone else's name. Right. So before you even think about protecting your own name, we always say the first step is conducting a search to see if that's even available for use, or are you going to infringe on someone else's name? You know, doing Google searches to see, does anyone else use this name? And if they're using it, are they using it on something similar?
Right.
Then actually going to the U.S. Patent and Trademark Office and doing a search there. You know, you can do a basic search. And then there's some other websites also that you can do searches on as well that are free. And we generally suggest a client do that first before they even consider moving forward with anything, whether it's hiring us to do a more detailed search, you know, because we have essentially software that we pay for that we do searches on, which provides a lot more than just any of the free searches will, as well as our analysis of those results. And then the next step would be deciding whether or not to file for a trademark or not to protect it. But the first step is making sure that it's clear for actual use, so you don't start spending money building a brand and a product and a website that would be infringing on someone else's rights.
Right.
So trademarks especially, I don't think it could ever be too early to start considering. Patents, there is a similar aspect there that you could start creating a product that would be infringing on someone else's rights. Unfortunately, and you know, I'll still suggest for clients to try and do their own searches to see if anyone else is selling something similar or if there's any patents covering it. But sometimes the cost of doing a clearance search in patents is just so astronomical because the amount of time and work that has to go into that, sometimes it's not worth it. Or sometimes at least at a certain stage, it's not worth it. I think that has to be, that's a very case-by-case analysis, depending upon what the product is, what area, what field they're in, things like that. I don't want to say never do it, because there is, in a perfect world, you would do it every single time. It's just when you look at it from a business perspective, sometimes, especially for a startup, the cost-benefit analysis is going to be really tough to come up with the fact that, you know, the 10 plus, you know, maybe $20,000, $30,000 that a true clearance search in the patent field would take. You know, if you know there's one competitor that you're just trying to get around their one product, that's a different story. But if we're just coming up with something new and we don't know anything. But again, before you determine that, I would always suggest speak to a patent attorney to just get an understanding of that, so at least you know you're making it from a business perspective and not just saying we're going to wing it.
It makes sense. I noticed, I was talking about this before we started, your tagline, you know, your auto signature has a registered trademark. And I know I have taglines, and I'm sure a lot of people that'll watch this have taglines. Take me through, I mean, when you would do, I mean, it's saying just as soon as possible is your answer to that before, but, you know, what happens if you use a tagline that someone else is using? Is there, like, what's the process there? Or someone uses yours? Like, take me through, if something's registered and someone's impinging, what does that mean?
Did you say if nothing's registered?
No, if you have something registered, let's say someone wanted to use yours, what happens?
Oh, if someone's infringing on, so if you actually have a registered trademark, most we file federal, so it covers the whole U.S. Unfortunately, there's no one worldwide filing, which is a question we're asked a lot. You generally have to file within whatever country, whatever jurisdiction you will be selling, or even if you're concerned that someone in that jurisdiction might use that trademark to counterfeit your product, you would need to file in each of those. But let's say you have a U.S. trademark, it's registered, it covers the whole U.S.
Right.
So it's as if you're using it in the whole U.S., and generally another cannot use it in there or anything similar to it.
Right.
So if someone's infringing, usually the first step is to send them a cease and desist or a notice of prior rights and tell them, hey, you know, we notice you're doing this, stop doing it, or we're going to move forward with a federal infringement action.
Right.
You know, and you hope that they respond to that and you can resolve it. If not, the next step is speaking to litigation counsel and determining, whether or not you're going to move forward with suing someone. That is one of the things that a lot of people, especially with startups, don't talk about, is that having your intellectual property registered, especially at the beginning when you're a startup, the real benefit there is that you have leverage then should someone infringe on your rights, as well as you also have, you hope that others, when they go to do their search to decide whether or not to use it, they'll see yours and move to something different. It'll has a deterrent effect, is what you hope also. Because generally, when you're in an early stage, the cost to litigate anything is very high, but intellectual property happens to have also a very high cost, as above even maybe sometimes just a regular contract dispute or things like that. Just given the nature of it, it's mostly going to be federal.
It would just take a lot of time and money, like you said. Right?
Yeah. So, I like to sometimes equate it to an insurance policy.
Right. So how much, take me through like the different costs, and then I want to talk about just some common mistakes that you're like, look, this is what people do and we can avoid them. But take me through a typical cost, because I know we're talking about, small like startups doing it, and we're trying to find the tipping point. Where are the costs fall for patent, trademark, and copyright?
Okay, so trademark, you're looking at around 1,800, which would include like a comprehensive search, which, looks at the mark. Can you use it? If you use it, can you also register it?
Right.
And also that covers generally the preparing an application, filing it, the filing fee, and pretty much all the way through to registration, assuming there's no major issues that come up throughout the process. And that would be for one class of goods or services. So I don't want to go too much into the detail because it's just going to get too confusing, but essentially when you file for a trademark, you say, I'm filing for t-shirts and bottoms or sneakers. But now maybe you're also using that brand on jewelry. Jewelry would fall into a different class, or even if you have a retail store, but you also then sell products under the same name. The actual retail store services or the online, e-commerce retail store, that's actually one service. And then the products you sell under the same name are a different class.
Right.
So we, also part of our consultation is figuring out what are you going to get the most bang for your buck in terms of filing? Should we file for 2, 3 classes, or should we just file, for the main product for now? And then at a later date, file to cover the other things when you've actually had, some more sales and you have a little more money in the budget to create a bigger portfolio of trademarks.
Right. Okay.
For patent, you're looking at, there's a wide range of patents because it really depends upon what the patent covers. A lot of times we have clients that come to us that have numerous inventions. So an invention isn't just the product. The iPhone or any cell phone out there has probably hundreds of patents that are in there. There's no one patent that just covers, this is a mobile cell phone. So sometimes clients come to us and they think, oh, I just have one invention that I need to patent, but they have multiple inventions. So the costs go up because of all of that. So sometimes what we'll do is file one application that covers everything, but you can only claim one of those inventions just to it'll be a little more upfront, a higher cost there, but then later in the stages, you can pull out those other inventions. Okay. Ultimately, you'll get a lot more at the end for the budget, but there's going to be a higher cost up front. And in terms of, patents, we always suggest at least some sort of a search before filing to really help the clients understand, well, what do we have here? Is there something that's even patentable? So we can do a quick prior art search, and prior art is essentially everything that's known before you file. The easiest way to say is these are the things that would stop you from getting a patent,
Right.
that the patent examiner would look at, or you'll hear a lot of cases that a patent is invalidated, after it's been registered. Sometimes they're invalidated because there was a piece of prior art, something that was known before that the patent office didn't look at. But when it's in a court case and they bring it up, they say, oh, this really wasn't a new invention because this existed before you. So we always suggest some sort of a search because it also helps us as the patent attorneys draft a better patent application if we know what we think the potential true invention that is entitled to a patent is. So you're looking at somewhere on, for the quick search, somewhere around $1,800. But then to really look at it and come back and say, this is what we think we can ultimately obtain a claim for, so that then we can sit down with the inventor or the company and decide, does it make sense from monetary perspective to file for a patent if this is what we can protect? Or is this so narrow that any competitor can get around it that it's not worth investing further? That you're looking at about $3,500 to $4,000 for a search where we do that.
Right.
Then after that, preparing and filing an application, you're looking at anywhere from 6,000 on the low range up to 12, 13,000 potentially. There's a really wide range, as I said, because it depends upon what you're adding in there, how many figures you're adding in. After it's filed, I generally say there's going to be at least another $7,500 that you're going to have to go through, because there's almost always going to be some rejection that you need to then go get around. But also when it is finally allowed, there's fees that you have to pay in order for it to register as well.
Right.
So, somewhere around the 13, 12 on the lowest end, but generally it's going to be closer to 20,000 is, I think, a good estimate for a patent.
Mm-hmm.
And for a copyright, you're looking at about, $800, $850 for, is what we charge, including our fee and the filing fees, the government fees.
Right. Okay, that's really good. So take me through then, knowing what those costs are. Someone says, okay, I want to do this. Take me through some common mistakes that people can easily avoid by either implementing these patents or timing wise. Just take me through a couple, so when people are thinking through doing it, they don't fall in a hole that we didn't cover today.
Okay, so I think one of the biggest things with patents is that sometimes, every once in a while I'll get someone that calls me and says, hey, I have this invention I'd like to file for a patent. And then when I start talking to them, it's like something that they brought to market 3, 4, 5 years before they ever reached out to an attorney about filing for a patent.
Right.
You can't file for a patent if you disclosed it more than 12 months before you file. So what I essentially want to say is, do not, if you're even thinking of filing for a patent, or even before you bring any product to market that you potentially think, even if there's a slim chance you think that you invented something new that would be patentable, speak to a patent attorney, because you can, by taking it public, by trying to sell it, you could lose the right to even obtain a patent on it. So that's a big mistake that I see a lot of people make, is they don't know that.
Mm-hmm.
In terms of copyrights, the biggest mistake is people think because they hired a graphic designer, a photographer, a videographer to do something for them and they paid them, that they own the copyright in the material that was created. Unless there's a specific agreement that says you own the underlying copyright, the copyright is owned by the person the artist, mm-hmm. the one that either creates the piece of artwork, whether it's digital file, whether it's the, photographer that actually takes the picture, the video editor that edits the video. they all would be the actual owner of the copyright unless there's something that says otherwise. However, if they're an employee of a company and that's their job at the company, then the company would be the owner just because it's automatically a work for hire. But when most businesses are starting up, it's usually a friend that's doing it for you, or you're hiring, this other company that you know of to create, your website even for you.
Right.
So you want to make sure that you own all the rights in the copyright, so that this way you can change it at a later date. You can do whatever you want with the files, and you don't have to worry that that artist is going to come back to you and say, you changed that logo without my permission. I never gave you the copyright in the logo. I just created the logo for you to use as is that file was.
That's a
huge mistake.
Yeah, that's a really good.
And trademarks, it's really just do a search. I mean, if you're going to be selling on Amazon, go on Amazon and do searches on Amazon. If you're going to be selling on eBay, go there. If there's, Google it. If there's an industry listing, look there. I just feel like there's a lot of these simple things that people could do to avoid having to change their trademark at a later date, as well as even avoid hiring me to do it, and then me realizing within, very quickly that there's issues there.
Right. Right. Well, I think we did a really good flyby of everything, Jason. So I'm
yeah.
But before we go, give me 30 seconds, the book, in case somebody listens to this. And I think we did a fairly good deep dive on all of them, but I also know that we've probably been talking for 20, 25 minutes. Take me through this book and how it kind of connects on some of these dots, and because I know it's kind of a passion project. We're all quarantined. This is your quarantine baby. Take us through what it is.
Yep. So it's basically, IP basics, intellectual property basics for building a successful business. And it takes you through a lot of what we've discussed, but in much more detail. It doesn't teach you how to file for a patent. It doesn't do that. It's more about helping business owners and startups identify the intellectual property in their company and start thinking about what they should do about it. And, there's some of the basic steps that we discussed here about like how to do a search, other mistakes to avoid, some simple steps like that. So yeah, the book's, we're editing the last version and working on the cover pages and things like that. So it's not out yet. It's, been going slow over these COVID times, but, it was something that I feel will help fix a lot of the mistakes that I just commonly see when new clients are coming to me. And sometimes even my own clients who I've done work for, then when they come up with a different business and start it, and I find out about it, a month or two in, and I'm like, wait, like, let's go back to step one. It's things that they could have avoided before investing any more money into the business, or before going ahead and doing something that then winds up being a liability because they chose the wrong name or they infringed on someone else's rights.
Right. Good. Well, I love it. And I thank you obviously you're very knowledgeable on this subject. We've had a couple talks about it, and I always learn something every time. So thank you for taking the time to come on and educate me some more. And look forward to seeing you in person when this whole thing gets done. And I look forward to the book when it comes out. So thank you very much. Really appreciate your time. I look forward to talking to you soon.
My pleasure, Eric. Thanks for having me on.